Good afternoon. My name is Anupam Chander. I'm with the International Law Center and I'm a professor here at UC Davis. On behalf of the center and on behalf of the law school, I'm delighted to welcome you here. I'm also delighted to welcome Jim Wood, who has been a leading litigator for many years. He has been previously a partner with Reed Smith at their Oakland and San Francisco offices. Reed Smith is a AmLaw 100 global law firm, one of these very important law firms in the world. He, while at Reed Smith and subsequently, he has done extensive pro bono litigation. And he's going to talk about some of this litigation that he has done. I'm going to just point out a couple awards that he's received for this kind of work. So he received the California Lawyer Angel Award in 2007 for his representation of California school children with diabetes to ensure that they receive care throughout the school day. He received the AIDS Legal Referral Panel Clint Hockenberry Leadership Award in 2014, given to individuals whose work reflects a lifetime of service to members of the HIV/AIDS community. We have invited Jim to speak with us today in connection with a long-running seminar series we have here at UC Davis, a seminar series on surveillance democracies. So the issues that Jim will talk about today involve the ability of the government to identify, in this case, a person with HIV/AIDS, and then the ability of the government to respond to that with kind of negative sanctions because of his status, and then his failure to disclose said status. So questions of privacy are very much at the forefront of the issues that we were concerned about in our seminar series on surveillance democracies. And it's a delight for me to invite Jim to speak to this, because this gives us a very interesting and important lens on this through a human being, through a real person whose life was upended by this kind of surveillance practice. So let's welcome Jim.
Thank you. Thank you, Anupam, for the opportunity, and welcome all to talking about privacy in the United States. And actually let me live out a fantasy when I was in law school. Before I went to law school, I was at the fork in the road. Do I want to go to law or do I want to teach? So I ended up really tipping to teaching, but I got talked into going to law, so this is an opportunity to feel something I should have done 40 years ago. I want to begin with something, and I hadn't planned to do this, but I'll tell you what my motivation for doing this kind of work is. About 10 years ago, Justice Ruth Bader Ginsburg was in San Francisco at the ABA meeting, and she received a pro bono award for that. And I remember every word she said at that time. And what stuck out with me, and that has guided me, and I hope you carry this with you into your practice as well, that every attorney has the right, the duty, the responsibility, and the obligation, right, duty, responsibility, and obligation to give voice to those who have none. I carry that with me, even in the firm. So I begin with what we're going to be talking about is the Privacy Act and how it is that the government violated the Privacy Act and how the courts ended up dealing with that violation. And I begin with a variant of Potter Stewart on obscenity, and that in this case, for privacy and damages, as you see through the journey of the courts that we went on, justices will say, you know it when you see it. And that's about the best that we can get here. As a quick background, when I was at Reed Smith, I did a lot of work for AIDS Legal Referral Panel. They called me up with this case about an individual who couldn't find a lawyer to do his case. He came in, had a whole PowerPoint about the violation of his rights by the federal government. I took a look at the PowerPoint. I said, this will be a fun case. We'll take a couple depositions. The government will settle, and boom, it'll be over. Here we go. Fasten your seatbelt. Well, the case was incredibly rich with irony. We ended up in trial court with Von Walker, who was the Prop 8 judge, a very smart guy, libertarian, and until he retired from the bench, closeted gay, but it was the worst kept secret in town. So you hear that our client is a gay pilot affected with HIV. We finagle a way to get in front of Von Walker. I thought this was perfect. Just as I thought, boom, the case is done. When I take some depositions, boom, I get in front of Von Walker, the case is over, gone, boom. This is a spoiler. This slide is a spoiler. And you see how it worked out. But we'll go through that. The second irony of this is that when we got to the Ninth Circuit, the justice who wrote the opinion, Monmouth Smith, is from a very large Utah Mormon family. Von Walker, Prop 8, Mormon justice. So I'll save Alito for later. Stanmore Cooper, he's the client. He was born and raised in the South. He was 68 years old 10 years ago, and makes him 78. Gay in the South, growing up gay in the South in the 40s and 50s. It was an incredibly traumatic experience for him. He moved out to San Francisco. Another irony of the case is that he worked for the Social Security Administration. He was a closeted gay in San Francisco when he came out to San Francisco in the 80s. Because of the trauma, emotional trauma that he experienced growing up gay in the South, he told me, and I found out later it was true, that fewer than this number of people in San Francisco knew that he was gay. Fewer than that knew he was HIV positive. Yet Stan's passion in life was flying airplanes. He loved flying airplanes within the gay community. We have all these different segments of people who love doing things. There's this gay community of flying airplanes. They would tweet each other. They didn't have tweet in that space, but they would somehow communicate with each other. Let's fly to Reno, and a group would fly airplanes to Reno, have a hamburger, and come back home. He loved flying airplanes. He loved building airplanes. In 1964 was the first time that he was licensed as a pilot. 20 years later, he was diagnosed with HIV, and at the time, the FAA had an absolute ban on issuing a license to anybody on antiretrovirals treatment for HIV/AIDS. Absolute ban. If you had AIDS and you were taking a retroviral, you did not fly. That disqualified you. Well, the thinking was, well, anybody with AIDS can go into senile dementia pretty quick. God knows we don't want them to fly in an airplane when they have senile dementia. Banned. So in 1985, he grounded himself because of that ban. He's an honorable person. In August of 1995, Stan became very, very sick to the point of death, and with his first case of full-blown AIDS. He applied for Social Security disability, Section 2 disability, and as a part of that disability, he submitted all of his records, medical records, HIV records, everything, to Social Security Administration in order to qualify for the disability benefits. A year later, he went to UCSF. That was at the point of investigating cocktails, mixtures of therapies for treatment of full-blown AIDS. He got in that program. He was lucky to get in the program. Within a year, his virus load got to the point that it was lowest in his entire life. He came back. But in 1998 was when the FAA finally permitted people to fly who had HIV to fly. But they did not publish what you needed to do or what your medical condition was in order to get that license. You gave them your records, you took your chance. Because of his passion for flying, and because of his knowledge about his health condition, he applied for a medical certificate for the first time in 20 years and did not disclose he was HIV positive. They asked him, he did not disclose it. 2 years later, FAA finally published what the criteria was for people with HIV/AIDS to apply for a license. Because he had not disclosed in '98 that he was HIV positive, he was terrified that if he disclosed in applications in 2000, 2002, 2004, they would go back and took a look at what he said and did not disclose he was positive for HIV. The government in FAA as well as Social Security Administration is governed by the Privacy Act of 1974 that was enacted primarily in response to the abuses of the FBI as well as the Richard Nixon administration, who had enemy lists, hit lists, and everything else, that did all types of surveillance on people and everything else. And it was at the point that computer data and all that were becoming fairly significant. The federal government appreciated this significance and came up with the Privacy Act of 1974. And essentially, the rule is that government does not disclose private confidential information unless you have the written consent of the individual who gave you the records. Except, and there are 14 excepts, but for the purpose of Stan Cooper, it was you could disclose to another agency for routine use. And routine use is one that is the information is exchanged within the purpose for which the records were originally disclosed. If someone at Social Security had medical records that would be useful to HEW for whatever reason, it had to be related to the original condition. The second exception, the one that applies here, is that a government agency can disclose confidential, private, personal information about an individual to another agency if there is a criminal investigation underway. If there's a criminal investigation underway. And if the agency asking for the records makes a written request, and if there's a law enforcement activity in writing underway. Okay? So if they're investigating a criminal investigation, they make a written request, and they have an open criminal investigation, they can go ahead and disclose without consent of the patient. All right, fasten your seatbelts. If there is a violation, and that violation of exchange and disclosure of records has an adverse effect, term of art, we'll get into that in a minute, has an adverse effect on an individual, and if that disclosure, illegal disclosure, was intentional or willful, intentional and willful, then the person whose rights have been violated is entitled to recover the actual damages of the harm and $1,000. So this is why I said, when he came in and told me his story, I know you had to have an adverse effect on you, and we'll see that in a minute what that was. And I'm pretty sure we can prove it's intentional and willful. And actual damages, I thought, easy. Here's Operation Safe Pilot. Federal government lied. Stan was indicted by the federal government for failing to disclose 4 times that he was HIV positive. He was indicted for 4 felonies. He was looking at 30 years in jail. He was looking at a $750,000 fine for failing to disclose HIV status. The purpose of Operation Pilot, and when he was indicted, there was a motion to suppress the records that had been disclosed. There was a declaration from Office of Inspector General for Social Security Administration that the purpose of the review was entitled to ensure that pilots with FAA licenses were who they claimed to be. And all this stemmed from a phonied up lie that they started this investigation after 9/11 to find out bad guys. What they wanted to do was to take a look at every pilot. FAA had all the Social Security numbers of the pilots who were flying airplanes at the time. Social Security had the true Social Security numbers. FAA will give them the Social Security numbers of every pilot in the country, and they'll match it up and find out who's lying about Social Security numbers. That's what they told the judge. That was a lie. What we found in discovery was that indeed the purpose of Operation Safe Pilot was to identify patient pilots who had not disclosed health conditions to receive their medical licenses and who had filed claims for disability. The chronology of Operation Safe Pilot, it was conditionally approved by the Office of Inspector Generals of the Department of Transportation, as well as Social Security Administration. And an Operation Safe Pilot, in order to find out lying pilots, people who had not disclosed medical health information in their applications every 2 years, who had lied about their health condition. That first, it was too big to do it nationally, so they decided to do in Northern California. The first thing they did was to get data on all pilots. I'm sorry, the first part was the one they did nationally, just to do identity match. November 2003, they sent information about 44,000 pilots in Northern California to Social Security in order to match Social Security numbers in order to narrow it down just for Northern California. Then they asked Social Security to take those 45,000 patients and identify who had filed disability claims with Social Security. FAA is asking who filed disability claims with you with the matches of Social Security numbers. Then they created a spreadsheet of all pilots in Northern California who had Title II benefits for disability. That included Stan Cooper. It included the fact that he had HIV and filed a disability claim for HIV, and others who identified who had made the Title 16 benefits. They came up with 226 pilots in Northern California who had filed disability claims, who had not filed or had not identified their medical condition at the time they applied for licensure with the FAA. 226 pilots, including Stan Cooper. Not only did they identify the pilots, but in October 2014, FAA requested and Social Security gave the 200 pages of medical records that Stan had filed with Social Security in order to get disability benefits. They took the 200 pages of his records and gave it to the FAA. Now remember that a condition for Operation Safe Pilot from the Office of Inspector General was that there be an active investigation going on about a pilot, that a U.S. attorney had been appointed and reviewed the matter, and that a criminal file had been opened. That didn't happen. Social Security gave FAA Stan's 200 pages of records. The records were reviewed by an FAA surgeon, took his deposition. He had absolutely no knowledge of background training or experience in HIV. And even now, that takes my breath away. The doctor, without understanding if Stan was physically qualified to fly even with HIV, recommended to the FAA that they do an emergency revocation. If you have any questions along the way too, if I'm not clear, ask them. Please.
Just a little, is that an error on the date on the very first?
Yes, it is 2004. Thank you for that. 2004.
Just a small thing.
Yeah, thanks for pointing that out. March 22, 2005, special agents from the Department of Transportation called Stan and said, we'd like to talk to you about some irregularities. We want to do it at Starbucks. Starbucks. Stan didn't think anything. They said, bring your license, your logbook, everything. This is what I talked to you about. The reason they asked for Starbucks is that under the investigation manual, that you don't need to give Miranda warnings to an individual if you're doing it in a public or semi-public place. That's under the guidelines of both agencies. If you haven't come to Starbucks, it's not custodial. If it's not custodial, you don't need to give Miranda warnings. These are bad guys. They have his 200 pages of records there. This is FAA special agents. They have the 200 pages of records. Imagine his reaction. How in the world did FAA get my medical records from UCSF? They said, you lied to us 4 years, give us your license, give us your logbook, and they gave him a suspension of flight. Only then, after all this happened, remember the condition for conducting the investigation? You had to have a criminal action pending, a file open approved by a United States Assistant Attorney General, and you had to have an investigation file open. Only after they talked to him So they opened a case against Cooper, and months after that, they opened an investigative file. Still taking my breath. This is the memo that I talked about how it was supposed to be done, that the investigation of the files was only to be done at the level of the Office of Inspector General in order to maintain some type of sense of investigation and not get down to the agencies themselves. Share the information only once the case is open. You've got the approval of the U.S. Attorney. And share the information once we've got a basis for opening a case and we've got the Assistant U.S. Attorney willing to consider charges. They did it backwards, absolute backwards. Cooper's indicted. Yes, sir.
So, quick question. Why did the FAA act in this manner? Was this because of the post-9/11 world, or?
No, actually, that was the excuse that they had post 9/11. I mean, everybody felt like any type of investigation was warranted.
Mm-hmm.
But there was, in Northern California, they indicted one pilot who had lied about his healthcare condition. 2 special agents from Department of Transportation, FAA, were involved in that investigation. They said, I wonder how many other people have done this. That's what started Operation Safe Pilot.
I mean, there's even a saying, this is specifically saying where pilots will delay treatment and diagnosis so that they can pass their physicals, usually.
The very first pilot indicted and tried before Judge Walker, of the 60 or so who were indicted, the very first pilot who was indicted was a American Airlines pilot, commercial pilot, who lied about Lipitor. Did not disclose Lipitor. They took that to trial. Judge Walker, hung jury. Judge Walker brought the U.S. Attorney and said, you settle every one of these cases. It's garbage what you're doing. That's why you're not. U.S. Attorney issues press release. Cooper comes home the afternoon of the indictment. He's driving home in the Castro. KGO TV is there. Camera's going. They tell him that he had just been indicted for lying about his HIV status. The headline on the afternoon news was, lying HIV pilot. Many more than this learned about Stan's HIV status. He eventually pled guilty to a misdemeanor, $1,000 fine and 2-year suspension or probation. The effects on Stan were significant. Being outed in this very public way was full of shame, humiliation, embarrassment, terror. Even in San Francisco, he didn't know what would happen to him. This describes what Stan's reaction was. In order to bring a case to trial, you just can't have somebody say, this is what happened to me. You need to have a psychiatrist, an independent expert, talk about what it is that happened to him. We hired this person who specializes in HIV/AIDS patients, a psychiatrist at Stanford, who came in, spent a long time talking to Stan, and identified that there was a DSM impact of being indicted, being outed by the government, and you can see what these are. There was significant emotional stress on him. It ruined his life. He became closeted in a different kind of way. He stayed home, became reclusive, terrified, worried about what his friends would think of him. And what the government ended up doing in discovery was to say, well, that had nothing to do with his outing as a gay man with HIV. Because he was indicted. Well, no. Stop. Okay, Operation Safe Pilot. In the courts, we initially filed a complaint on 2 bases, 2 theories of liability. One was first was a violation of the Privacy Act. The other was for the violation of his constitutional rights under the California Constitution. Article 1, Section 1 of the California Constitution guarantees the right of privacy of every individual in the state. So I thought it was pretty good. That government filed a quick motion to dismiss. It's not available information is shared with third parties. And more importantly, the Fourth Amendment does not prohibit the obtaining of information released to a third party conveyed by government authorities. So essentially what that is that if you give your confidential information to the government, you have no reasonable expectation of privacy under the Constitution. That did not, I'll say that again. If you give confidential information to a third party, including the government, the courts will say you have no reasonable expectation of privacy, which is necessary for a privacy tort. So we were left with the Privacy Act. And in the criminal investigation, the criminal case, Stan filed a motion to dismiss, a motion to suppress evidence of the investigation because of the violation of the laws of the Privacy Act. Judge Walker denied the motion, and I put the second paragraph in here because this really became what the theme throughout the case was. This became the theme of what the case was, and this is why I go back to the variation of Potter Stewart's definition of privacy. And Judge Walker, a very bright judge, concluded that society is not to prepare that expectation as reasonable. He made a public policy determination that societal values were not ready to give the kind of protection that Stan Cooper expected under the Privacy Act or under the Constitution. All right. So we filed the complaint, and it was the discovery fight that we had was unbelievable. I sound like Donald Trump. Unbelievable. We admitted that the damages were limited to emotional distress damages. He had no out-of-pocket expenses. He did not seek therapy, didn't see a doctor, didn't take any drugs, because he was taught in the South that you just kind of suck it up. You just suck it up and you do it on your own. You don't need the help of anybody. So we were limited to emotional distress. The discovery fight was everything you could imagine that you have in a fight with the government. We would request documents. Sorry, give us all the documents you have about Operation Safe Pilot, and they would give us emails to and from, and then this big black square redacted under national security. Judge Walker essentially said, give them everything. We then filed simultaneous motions for summary judgment. We filed plaintiff motion for summary judgment, defendants, FAA, Department of Transportation, and Social Security filed their summary judgment. Long argument on it. We gave them all the discovery. Judge Walker found that they had violated the Privacy Act, that there was an illegal disclosure, there was no criminal investigation going on, there was the disclosure of records by Social Security to FAA violated the Privacy Act. He found correctly that the issue of willful and intentional, the second prong, was a tribal issue of fact. That would have been fun to try. Remember actual damages? Remember your tort class? Did you ever hear of actual damages in torts?
Some of them haven't taken torts yet.
Oh, we haven't taken torts. I will tell you. You will not hear the idea of actual damages in your tort class. General, special, exemplary, punitive. You will never hear actual damages in the class. I guarantee it. Sound like Donald Trump again. Because, yes, did you have a question? Okay. Because we were suing the government normally has sovereign immunity unless there's a clear and express waiver by the government that they can be sued. We argued that the Privacy Act, in identifying what a violation is, and identifying willful and intentional, and identifying actual damages, was a clear waiver of sovereign immunity. I didn't see this coming. The motion for summary judgment that we had a very brief discussion about, Stan had actual damages, emotional distress. We gave him the declaration of his emotional distress. We gave him the doctor's declaration of emotional distress. Judge Walker found that emotional distress satisfied the element that you needed to have for an adverse effect. It gave him standing to bring the lawsuit. The emotional distress was an adverse effect of the violation of the Privacy Act. So we got into court. That Judge Walker found that the use of the phrase actual damages was vague, and by being vague did not reflect a clear waiver of sovereign immunity by the federal government. Actual damages was vague, no clear waiver, summary judgment, entered for defendants, case dismissed. There goes the quick, we'll take a couple depositions and they'll settle. So, the statute, as I say, is that they're liable for actual damages sustained, but the court said actual damages is facially ambiguous, and that under the law of waiver of sovereign immunity, any ambiguity is construed in the favor of the government and against the individual. Stan Cooper had no claim against the federal government for violation of his privacy rights under the Privacy Act. Now, the irony of it is that we had come up with Stan buying one bottle of aspirin. That we had one bottle of aspirin. That we had, in going to see a doctor once, and pay $150 to that doctor for the examination. Perfect. We would the case would have been great. We could have got the emotional distress damages in, but that we had to prove some special damages, out-of-pocket expenses in order to get the emotional distress element. We didn't have any of that. Actual damages did not include emotional distress damages, case dismissed, and off we went. Ninth Circuit, we went up and we took a look at the panel that we had, and it was not a good panel for us. Essentially 3 Republican appointees. One of the justices was so old, he was in Montana, he had the argument on a conference call, and we all know what we do. I know what I do when I'm on a conference call. I don't pay very close attention, so we thought it was just the worst imaginable pick that we could get. They held that actual damages encompasses both pecuniary and non-pecuniary damages. So out-of-pocket expenses and emotional distress. And they concluded that there's no ambiguity, that there's a plain meaning to what actual damages are. They took a look at Congress, Supreme Court, and the circuit courts that have looked at the issue of actual damages. And the Congress, in the Privacy Act, the right of privacy is personal and fundamental right protected by the Constitution. Supreme Court, in the case of Tymeen versus Hill, in privacy cases, the primary damage is the mental distress from having been exposed to public view. In privacy cases, the primary damages is shame, humiliation, emotional distress. And then the circuit courts, the 1st, 3rd, 4th, 9th, 10th, and DC circuits, had defined actual damages to include emotional distress. So they concluded, 9th Circuit unanimously concluded that, in a published opinion, that actual damages was not vague, that Judge Walker had not given enough consideration to the history and the phrase of actual damages, that implicitly that he had been wrong earlier in taking a look at what the societal value was to the expectation of privacy. And they also took a look at other extrinsic sources. They refused to take a look at the legislative history on this because, as they described, it's murky, ambiguous, contradictory. They analogized to the Fair Credit Reporting Act as well as the Fair Housing Act, that provides for recovery of actual damages, and courts have said that in those cases where there is a violation of the Credit Act and the Housing Act, that actual damages is emotional distress damages without proof of out-of-pocket expenses. So you had the authority of courts using the same words, actual damages, two independent statutory settings, say it includes emotional distress, and the Ninth Circuit concluded, yes, it's clear from that as well that actual damages in this case under the Privacy Act includes emotional distress damages. And then they were critical of Judge Walker for taking a look at the sovereign immunity part of it and just kind of a knee-jerk saying it's not clear, therefore sovereign immunity applies. They reversed it, not over, federal government petitions en banc for a full hearing. In the divided vote, they voted to affirm the Ninth Circuit. So because of the conflict within the circuits, off we went to the Supreme Court. And we found ourselves in a situation similar to today, where because Justice Kagan recused herself, because when she was Solicitor General, the petition for cert had gone through her office, and she had to practice any case that went to the Supreme Court while she was Solicitor General, she automatically recused herself. So that left as our target Justice Kennedy. And we had, I forget how many mock arguments, and we had different groups join us, privacy groups joining us on this as well. And every argument that we crafted, I didn't do this, God knows I didn't do this one. It's, I always tell people it's kind of like a general practitioner doing brain surgery. And we have an appellate group, an appellate specialist who came in and did the argument. And I always described it as kind of parenthetical, but I always described it as a younger lawyer than I am, but he was my lawyer throughout the time it was at the firm, one of the smartest people I knew. And this was his first Supreme Court argument. So every mock argument that we had was shaped in a way to get to Justice Kennedy. Forget everybody else. We knew whatever it is that we said, we would have everybody else, and we knew who would vote against us. We had to get Kennedy. There you have it. We ended up with Justice Alito writing for the majority and Justice Sotomayor writing the dissent. Totally predictable, except for Justice Kennedy, and we thought for sure we had him from the questions that he asked and everything else. And again, parenthetically, even though I'm not an appellate lawyer, going into the Supreme Court, sitting at the council table, listening to the arguments was a highlight of my career. I go back to sitting down with Stan Cooper and his PowerPoint and saying, okay, well, some depositions and they'll settle, and then here I am. And you remember that this will happen to you. The trial court threw our case out because of his interpretation that actual damages is vague. His visceral reaction was that actual damages is vague, therefore no waiver. Ninth Circuit, actual damages is clear. We understand it, and we take a look at the purposes of the Privacy Act, and it's clear, and there is a waiver of immunity. And this is why I keep coming back to Potter Stewart, is that people taking a look at the same phrase. Do you know what I'm talking about when I say Potter Stewart? Okay. There was an obscenity case in the 1960 something. a piece of literature, I can't even remember what it was. And the question that came up to the court was, is this piece of work obscene, and therefore that it should be banned? And the majority went through this whole analysis about appealing to prurient interest and kinds of stuff. They came up with this test. Potter Stewart said, well, never mind the test. We don't need a test, because with obscenity, I know it when I see it. And that with Potter Stewart's guideline is that if I see something and it's obscene in my mind, it's obscenity and it can be banned.
1964.
64. Boy, am I old. So, you know, when we're beginning to see, and this is my, my reaction to what I saw with, throughout the process, and we'll get the Supreme Court decision in a minute, is that essentially the opinions of the courts throughout this process were result-driven. By that I mean, very smart judges, but they have an outcome. They knew where they wanted to go, and then they shaped the reason around it. And that's what, I think that's what they're able to do when you have a phrase like actual damages, that it's not a common phrase used in the legal lexicon. So the majority went through this analysis. I was going to put up, this was classic excuse me for a second. This was classic Scalia. At one point he was going back and forth with my partner who was representing Cooper on the appeal before the court. And he said, you know, all this Privacy Act and everything that you're talking about is picky, picky, picky. And, you know, that's not very legal, not very deep, but the holding of the Supreme Court majority opinion is that actual damages as a matter of law does not include claims for emotional distress. And they went through the reiteration, did a lot more than the judge did at the trial level, that the waiver of sovereign immunity is not unequivocal. And they took a look at Doe versus Chow, which was the first Privacy Act case to come before them. The question Doe v. Chow was whether, remember, the penalties for violation of the act were actual damages and $1,000 for violation. The question before the Supreme Court in Doe v. Chow, which we used earlier, was whether the $1,000 penalty was a standalone or if you had to have some other damages. So this was the second time that they were looking at the Privacy Act. And he got, I read this again the other night, and Alito gets going on about how actual damages parallels libel per quod and slander. And that for libel per quod, that is that if you libel somebody and it's libelous only in the context of where you are, who you're with, it's not a standalone libel. Under the law, you have to prove that there was special harm. After the Privacy Act was passed, there was the Privacy Protection Study Commission that decided to leave the question of general damages to somebody else. They go through a convoluted analysis of the Fair Housing Act, Fair Reporting Credit Act, and in dealing with the question of absurd results, he kind of dismissed it in probably a quarter of a page of the opinion. You remember that there was the idea in the Time versus Hill case that the primary injury for invasion of privacy is the emotional shame and embarrassment of a very private personal fact being disclosed to somebody. That's the natural outcome of a violation of privacy. The shame, humiliation, and embarrassment. That's the consequence of it. That's the natural consequence of it. And Alito and the majority's resolution of this is, it leads to an absurd result, that if somebody discloses a very personal, embarrassing point about you, as was the case of Stan, if he bought a bottle of aspirin, he had a claim. Without that bottle of aspirin, he has no claim. And Alito dismissed this in saying Congress intended to cabin relief, not to maximize it. That's a weird way of saying that they don't want to pay. And you know, it was a very quick dismissal of taking a look at what the impact and what the outcome was. During the argument, there was Justice Sotomayor and Justice Ginsburg all over the government attorneys in the argument and throwing softballs to my partner about the act. But as it turns out, Justice Sotomayor wrote the dissent. And I put these up because it says it all to me. Society, in my mind, will accept the fact that if something very private and personal in our lives is disclosed in a way that we don't want it to be, I'm going to be devastated by that. It's natural, that's human. And her conclusion is, with the majority, that no matter how bad the disclosure was, no matter how bad the violation was by the government or anybody else, no matter how badly the government has acted in disclosing private personal information, unless you buy that bottle of aspirin, you're out of court. That's the natural consequence of the majority opinion. She concluded, too, that that's not the result that Congress had in enacting the act, that Congress did not create a standard law prohibiting a violation without wanting to provide a remedy. With the majority opinion, you can have a violation, but there's no remedy. That doesn't make sense. So she went through a very careful analysis of taking a look at statutory construction. I know, I'm not objective about this at all, but I think the dissent was a great opinion. It was really well written. She took a look at Black's dictionary at the time that the law was enacted in 1974, that actual damages, the definition of actual damages in Black's Law Dictionary at the time when the law was enacted, included real, substantial, and just damages or an amount awarded for an actual and real loss or injury. Actual, real loss or injury. Not anything having to do with pecuniary loss, nothing having to do with out-of-pocket loss, but very broad, and any kind of injury is included in actual damages. Emotional distress, temporary damages, all of it. Birdsall versus Coolidge, compensatory and actual damages mean the same thing. That is, that the damages shall be the result of an injury alleged in proving. So in a very broad sense, at any time that you have any kind of injury, if you prove that there's been a harm, or if you prove that there's been a violation, and you prove harm from that, that is actual damages. Took a look at the Privacy Act. There's nothing in the Act to suggest that actual damages are compensatory damages, out-of-pocket damages. The provisions, as I said, that the purpose of the Act was to prohibit a violation, and if there's a violation, to provide a remedy. It's simple. You know, any law that is enacted, that if there's a prohibition on something, there's a penalty for it. If there's something that compels you to do and you don't do it, there's a remedy for it. Otherwise, it's just don't do it and you get away with it, which is essentially what the government did in this case. And that's her last point of actual damages are only pecuniary damages. There would be violations without a remedy, which doesn't make sense. Whenever you have a free moment, there's not a whole lot of those in your lives anymore, is there? But take a look at this description of defamation for plot, and that's, your head will just spin. And Justice Sotomayor's response to that is, in going back to a legal concept that is not used in the Privacy Act, you're rewriting the Privacy Act and you're using words that Congress did not have there. Defamation and libel's got nothing to do with privacy. So you're just making it all up. She went through the history behind actual damages, and the Privacy Act started off in the House and the Senate. They came up with two separate versions. The Senate had actual and special damages. The Senate used the word actual and special damages. The House permitted general damages only. General damages were deleted in the final version, so you were left with actual damages. And her interpretation of that is that getting rid of general damages, leaving actual damages. Actual damages are not presumed damages, but provable damages. Special damages, you presume to have been harmed, and you just got to prove what they are. But she concluded that actual damages are provable damages. Then she took a look at the purpose of the Privacy Act as written by Congress, and I'm repeating myself at this point, but the purpose was to create a right of privacy, to prohibit the government from violating privacy, and to give a remedy after that. And she quoted that and correctly comments that the majority opinion ignored and forgot about what the goal of Congress was. You ban them from doing something, remedy if they can't violate it, they can't violate that, and you give a remedy. You'll learn that in course. You won't see this kind of convoluted kind of thing. So, case ended. Okay. Well, I just want to point out what happened right after, because that's not the end of it. Case of since goes back to Judge Walker, he throws it out. We applied for some attorney's fees, and frankly, by the time we took a look at, billable hours and rates at Reed Smith are substantial. So they took a part of what our hourly rate was. And with the team that we had in place, we figured that we had about $2.5 million worth of time in the case. And it was an extraordinary experience we had. We had very young associates working with them, young associates taking depositions, helping draft a summary judgment. We took a second-year lawyer who worked on the case with us, sat at the counsel table at the time of the Supreme Court. But, it was a significant and important expression of Justice Ginsburg's admonition that it's a right, duty, responsibility, and obligation to give voice to those who have none. So it did not end badly. Stan, and this is, I said the case is loaded with irony. Stan, at the conclusion of the case, wanted to fly again. In order to do that, he had to resubmit an application for each of the years that he lied about. He sent his medical records to the FAA, and they told him that every year he would qualify. If you had submitted the records in 2000, 2002, 2004, and 2004, you would have been approved. The FAA did end up changing the notice that they give, and now, when you have any type of disclosure of the Privacy Act and any government document you get from Social Security or anybody at all, if they disclose what the uses are going to be, then that's okay. When Stan applied for his licenses, they did not say that they would exchange records within government agencies if you're under criminal investigation. FAA, OIG went before Congress, said that they screwed up on this, and that as a result, they did change the medical certificate. Senator Daniel Akaka submitted legislation to change the law to make sure that the Privacy Act did include all forms of damages, emotional distress, actual pecuniary, everything, to overrule FAA versus Cooper, introduced that in legislation, and that law was filibustered by the Republicans and died. There you have it. I think we can do much better than what it is that this case shows. That, as a society, as a people, as lawyers, and I guess my challenge to you is just to give voice to those who have none once you get out there. Any questions?
So we should probably take the questions right afterwards, because I know that some people will have to leave
Okay.
at this moment. So let's thank Mr. Wood.
Thank you for the opportunity. I love talking about